Are we ready? Welcome to everybody who's here for our Human Rights Workshop. It's the MEFM Society of BC. And welcome to, how many people do we have online? Does anyone know? No? Oh, anyway, welcome to all of you who are at home. 6? Okay, great. Hello. So we did the live stream last year and we thought it was a good idea to do it again. Hopefully we can have this build. There's a Q&A at the end of the presentation and we have some mics here that we will be using. So you can save your questions, write your questions, send in your questions. Thanks to James Haldane and his trusty assistant. What's your name again?
I'm Ian, I'm not an assistant.
Oh, you're not, I'm sorry. Okay, colleague. Ian, for running the live stream, and Rochelle, our program manager, is managing the online participation. I'd like to welcome our presenter, Laura Track. Laura is an experienced human rights lawyer with a passion for justice, and you can see her. Is the description for Laura online? So I won't read it out. Yep, okay. So you can read Laura's background, and she's got a background with the BC Human Rights Clinic. And this came about because a member of our society was having issues with the Ministry of Social Development and Impoverishment that was not recognising her status with ME, was also having difficulties, various difficulties with getting diagnosis, and eventually we were talking about the possibility of it being a human rights issue, and in the course of that we thought, well, this would be an interesting workshop to present to our members, because of course with the stigma involved with ME and FM, patients run into roadblocks all the time with physicians, with the ministries, with various services. And so learning how to avoid getting into a big legal battle and what benefits are there and what exactly is a human rights approach to this issue. That's the answer we're looking for from Laura. And without any further ado, Laura, would you like to come?
Hi, everyone. Thank you for the introduction, and thank you very much for having me this afternoon. I'm really glad to be here with you all. My plan is to present for about an hour, and there'll be lots of time for questions at the end. I'm also really happy to take questions during the presentation, unless that is difficult to navigate with the microphones and so forth. So we'll just see how it goes. But if something does pop into your head, either ask for a microphone or just hang on to it until the end of the presentation. I do these workshops often, talking to folks about human rights, the Human Rights Code in BC, how it works, what it protects, and some of the advantages and disadvantages of engaging that system to try to deal with discrimination in our lives. And for today in particular, I've focused the presentation in on some of the particular themes and topics that I hope will be of most interest and relevance to this particular group. But again, at the end of the presentation, if there's anything you feel I haven't covered or that you were really hoping to learn more about today, please do raise that and we can see if I can offer any insight into what you're wondering about. I work at the BC Human Rights Clinic. The clinic is a part of the Community Legal Assistance Society, or CLASS. We're a legal aid type organization, a legal nonprofit located in Vancouver, and we've been running since the early 70s, since 1971. CLASS has 3 different departments. The Human Rights Clinic is one. We also have a mental health law program and a community law program that works more on poverty issues, workers' rights, income security, and so forth. And the Human Rights Clinic is the place where I work. And focusing in on the clinic specifically, we provide free legal services to people who have human rights complaints proceeding through the complaints process. That might look like a short consultation of a couple of hours to provide some what's called summary legal advice, a little bit of assistance to people as they go through the process, all the way up to acting as someone's lawyer and representing them at a hearing. We have legal advocates and we have lawyers on staff, and we try to serve as many people as we can, which means we can't serve everyone as fully as we'd like to be, but we try to at least provide some assistance to as many folks as we can through either information or advice. And then, as I said, all the way up to a full representation. We do have a drop-in clinic that operates on Mondays out of the Human Rights Tribunal office downtown. And that's a place where anybody can go, even if they haven't got a human rights complaint going already, where we'll provide half an hour of information and advice to folks and help them think about whether a human rights complaint even makes sense for the issue that they're dealing with. We can talk about what's going on with them and think through what a human rights complaint might look like. And then the fourth thing that we do is workshops like this. We do education and training, both for community groups and people like yourselves who are more likely, I think, to be on the complainant side of the human rights tribunal process. But we also do workshops for people who are more likely to be on the receiving end of a human rights complaint. So employers, service providers, landlords, human resources professionals and companies, people who have obligations and responsibilities under the Human Rights Code. We help them understand what those responsibilities are so that hopefully we can avoid anybody having to make a human rights complaint and go through the litigation process. So my plan for today is to talk a little bit about what human rights are, where they come from, and how they're protected in law. I'll talk about the BC Human Rights Tribunal, which I've mentioned already, and introduce some key concepts in human rights law to all of you. We'll go fairly quickly through these first couple of slides, but I think that we all sort of come to the idea of human rights with a real sense of what human rights are and where they come from. And we often think of human rights really broadly, and they are broad, and they are big, important philosophical concepts. And I sort of see human rights in this kind of a funnel, where at the biggest level, we have international human rights, declarations and treaties and agreements and covenants to protect human rights that different countries actually sign on to. International agreements, often sort of held by the United Nations. The first of which, many of you will have heard of it, is the Universal Declaration of Human Rights. The Universal Declaration was signed and implemented in the aftermath of World War II, when countries were sort of reckoning with what the world had just gone through and committing to not allow something like that to happen again, and to creating a legal structure whereby countries would agree to certain sort of fundamental human rights and freedoms. Over the years since that time, a number of other international documents have been negotiated and agreed to by many, many states, including the Convention on the Rights of Persons with Disabilities, which is a very important piece of international law that protects the human rights of people with disabilities. And there I could have picked any number of other treaties and agreements to reference. There are agreements around racial discrimination, around ending discrimination against women. UNDRIP is very much in the news these days, the Declaration on the Rights of Indigenous People, and so forth. These are examples of international human rights law, kind of the biggest part of the funnel. Narrowing that in a little bit, bringing it a bit closer to home, we have the Canadian Charter of Rights and Freedoms, which also protects our human rights and protects them in a somewhat more, from my perspective, more meaningful way than international human rights law does, in that we can actually go to court and allege that there's been a violation of our charter rights and freedoms. The charter is enforced by Canadian courts, whereas international human rights law, not so much. It's really difficult to enforce international human rights law. It's more aspirational, I think I would say. But the Canadian Charter of Rights and Freedoms protects a range of rights, including equality rights, the right to non-discrimination, which is going to be the focus of most of our time together today. But sort of narrowing in even further to the law that, from my perspective, is most applicable and most relevant to our day-to-day lives is human rights legislation. Specifically, on the right there, the BC Human Rights Code. And the reason I say that this is the sort of narrow end of the funnel and the most applicable to our day-to-day life is that the Charter really only applies to government, to state action, but the BC Human Rights Code applies to our day-to-day interactions with our employers, our landlords, our service providers, people that we're dealing with directly day to day. And because it's Canada, and Canada is a complicated federal system, there is a Canadian Human Rights Act, where if the service that you were being provided or your employer was a federally regulated body, like a bank, an airline, or a telecommunications company, for example, it might be covered by the Federal Human Rights Act. I'm not going to say too much about that because the vast majority of the interactions that we have where our human rights are kind of implicated happen within provincial jurisdiction. And as I said, in our jobs, in our homes, and in our access to services. So the bulk of my presentation from here on out is going to focus on the BC Human Rights Code, which is the human rights law most applicable to us here in our day-to-day lives in BC. And the code, what it's designed to do is protect us from discrimination. It covers employment, tenancy, and services within BC. And in BC, we use what's called a direct access model. People can make a complaint directly to the BC Human Rights Tribunal and have it adjudicated. There's no gatekeeper to that process. That's in a bit of contrast to the federal system where the Canadian Human Rights Commission actually investigates complaints first before referring them to the tribunal for a decision. In BC, we don't have that. People just go straight to the tribunal with their complaints. As an aside, you may have heard that BC is bringing back its Human Rights Commission. We did have a commission that acted as a gatekeeper until about 2002 when the government got rid of it. The commission is coming back and we should see legislation introduced to bring it back in probably a month or so. But the plan is not to bring back in that gatekeeper function. The commission is going to be doing more education work, more systemic work, inquiries, investigations, and so forth. So I think it's going to make a really nice complement and addition to the human rights system that we have. Every province in Canada and territory has a human rights law. Many of them are also called codes. Some are called acts. In Quebec, theirs is called a charter, but they all do basically the same thing. They protect individuals in that province from discrimination in regards to their employment, their housing, and services. And the BC Human Rights Code is enforced by the BC Human Rights Tribunal. The tribunal is like the court where human rights complaints are heard. It's not exactly a court, but it is the enforcement arm of the Human Rights Code. I said it's not a court, it's what's called an administrative tribunal, which is like a court, and it hears and decides human rights complaints. One thing that is really wonderful, I think, about BC's Human Rights Tribunal is that it's free to use. If anybody has ever initiated litigation in another area of court, in small claims court or in, God forbid, BC Supreme Court, you know that even just getting in the door and filing your claim costs money. The BC Human Rights Tribunal does not. Anyone can file a complaint. It's free. The forms are free, freely available online, and there's no fee to file your complaint. The tribunal also offers free mediation services, which is, I think, another helpful thing that the tribunal can do. It can help people to potentially resolve their complaint without the need for it to proceed all the way through the process. And again, those services are provided for free by the tribunal. I've mentioned that the tribunal hears discrimination cases and makes decisions about whether discrimination happened. And if the tribunal finds discrimination did happen, it can order remedies. It can order compensation to people who have experienced discrimination contrary to the code, as well as other remedies, and I'll talk about those in a moment. Separate from compensation orders are what are called costs. And again, if anybody has engaged the legal system, you may be familiar with costs. Costs are when the losing party has to pay the legal fees of the successful party. And happily, the tribunal very rarely orders costs. Costs serve as a real deterrent, a real barrier to engaging the legal system in other contexts. Who wants to take the risk of bringing a complaint forward only to potentially face thousands of dollars in costs if their complaint is not successful? That's a real fear that many people have about using the court system, but the tribunal system doesn't award costs. Even if you lose, you have to behave very badly in order to have costs awarded against you, engage in the process in bad faith, abuse the tribunal's process, not follow the rules, etc. So very rarely are costs awarded. I'm going to say more about the deadline, but just to flag right off the bat so you have it in your mind, there's a 6-month deadline to file a human rights complaint. You must file your complaint within 6 months of the event you believe is discrimination. And I'm going to say more about that in a moment, but it's important to flag right up front because it's a very fast deadline. We're hoping that maybe over the next little while, the deadline gets lengthened and changed. It used to be a year, and it's possible that that might be a change that's on the horizon. So who can bring a complaint? Well, there's different ways of framing a human rights complaint. An individual can, of course, bring a complaint. That's the most common kind of complaint that's brought forward. An individual experiences discrimination. And again, I'm kind of foreshadowing things that we're going to talk about in more detail, like what is discrimination. But an individual can bring a complaint forward about discrimination that has happened to them and seek a remedy. Individuals can also bring complaints forward on someone else's behalf. So we see a lot of parents bringing complaints forward on behalf of their children, often against schools who are failing to provide enough support for a student with a disability who requires special needs. We see a lot of those cases at the Human Rights Tribunal. Individuals can also bring complaints on behalf of someone else who may lack capacity to bring a complaint on their own, or who gives them permission to bring the complaint on their behalf. And even though it's an individual complaint, individual complaints can still bring about what we think of as systemic remedies. They can bring about things like policy changes. So even though a complaint is brought just by one person doesn't mean that the impacts of that case can't have significant knock-on effects for other individuals. Two other ways of crafting or putting together a human rights complaint. A group of people could bring a human rights complaint if there are specific individuals who have all experienced the same kind of discrimination from the same person or entity, like an employer. Maybe there is a group of women who want to bring a case forward against their employer for failing to deal with sexual harassment in the workplace. There's a kind of group of people, identifiable people, and they have been affected by the employer's behavior and they decide to bring a complaint forward. Similar but a little bit different are class complaints. Class complaints are brought by a number of individuals who can be identified by characteristics they share. So right now there's a class complaint proceeding in BC. It's at very early stages, but it's been in the news a little bit, so I can tell you about it. And the class is people who are deaf in BC who have been trying to access a particular service and have been denied interpreter services. So the class is made up of individuals who have gone through that, but at this point we don't know exactly who they are. They're defined by the characteristics they share of being deaf and having tried to get this service and have been denied. So a little bit different. I mentioned that the tribunal can award remedies, that can award compensation for discrimination. And on the kind of monetary piece, there are two categories of compensation that the tribunal can order. The first is called injury to dignity damages. And these are the sort of subjective, personal impacts of the discrimination on the person. They're meant to reflect the hurt, the impact, a perhaps more familiar term is pain and suffering that the discrimination caused to the individual. And so the greater the impact of the discrimination, the higher the award in general. Now, importantly, injury to dignity awards are meant to compensate people for the impact of the discrimination. They're not meant to punish the person who discriminated. I sometimes have to have that conversation with my clients who really and rightly want to punish the person who has treated them badly. And I understand that, but it just isn't the way the tribunal works. The tribunal is going to try to understand what the impact of the discrimination was on the person and make an award that, based on decisions that they've made in other cases, kind of falls in line with the impact. So you can appreciate that it's a very subjective and tricky determination to make. And of course, there's the argument that no amount of money can truly compensate someone for the impact that being treated unfairly has on them. And unfortunately, that's not really something the tribunal can grapple with. They have the option of awarding money, and in addition to the systemic remedies I'll get to in a moment, that's sort of where they're stuck. And injury to dignity awards in BC are not terribly high. The average in the employment context in BC is about $5,000, which, I mean, is a lot of money, but is not a windfall, certainly. And sometimes folks are surprised by that, that the awards are so low. The other category of compensation that the tribunal can order are what are kind of more concrete losses, things that you are like out of pocket as a result of the discriminatory treatment. So if you were fired, you may have lost wages or weren't paid severance. Maybe you were receiving benefits, but obviously after being terminated, you no longer did. The cost of attending the hearing, the loss of the opportunity to advance in the company. Maybe you had to go and re-educate or retrain after you were terminated for discriminatory reasons, and you incurred costs to do that. Those are the kinds of sort of concrete economic losses you could provide a receipt for and prove. And if the tribunal agrees that, yeah, those losses are connected with the discrimination, then they can award compensation for those kind of real concrete losses. I do flag there on that slide, though, that an employee has a duty to mitigate their losses, so does have an obligation to take steps to find a new job, for example, or mitigate their losses in some other way, generally by finding a new job. Yeah, I'll leave that there. Systemic remedies. So I've touched on this already. The tribunal can award not just monetary compensation, although that is what most cases come down to, but it can also award or order policy changes. The tribunal can also say the way you're doing things right now is discriminatory. It's having a discriminatory impact on a particular group and it needs to stop. And so you need to figure out what that looks like. And here's some guidance for you about how your policy needs to change, how your practice needs to change so that the discrimination doesn't continue to occur. The tribunal can also order that accommodations be put in place. Often cases that are brought on behalf of people with disabilities or by people with disabilities, they're seeking accommodations, either in their jobs, in their homes, or in their access to services. And the tribunal can say, failing to provide these accommodations is discrimination. You need to build that ramp or change this layout of the workplace or implement a well, this would be more the next one, implement a scent-free policy, for example, in the workplace, or change the chemicals that the cleaners are using because it's having an impact on somebody's breathing disabilities, for example. So they can order accommodations. Those accommodations might be in the form of a posting of notice to the rest of the workplace, and they can also order education and training, human rights education and training for employers or service providers or others who, it seems, may need some more information about their obligations under human rights law. I'd like to include this slide. I know it's a lot of text, but the purposes of the code, just because the language is, I think, so aspirational and so fundamental and really gets to what we're trying to do through human rights law. I think that this idea of promoting a climate of understanding and mutual respect where all are equal in dignity and rights, I mean, that sounds great, doesn't it? Couldn't we all use a little more understanding and mutual respect? And I think that D is also a really significant one. And this is, this is enshrined right in the law that we're dealing with, identifying and eliminating persistent patterns of inequality associated with discrimination, right? Eliminating systemic inequality. That sounds pretty good too. That's what the code is supposed to be about. That's what it's designed to do. That's its purpose. And we can have a conversation about whether it is fulfilling that purpose, given that we know that systemic inequality persists, but nevertheless, this is one tool that we have in our toolbox to attempt to address it. I've used the word discrimination a lot already, so let's unpack it a little bit. What is discrimination? What does discrimination mean? This is a part in the presentation where I often kind of turn it over to you. I'm not sure if that's gonna work in this situation, but I think it will. I'll just repeat things back if you shout out some ideas. What is discrimination? What does that word mean to you? Any ideas?
Lack of access.
A lack of access. Awesome. Thank you. What else?
Not being included.
Not being included. Good one. Thank you. Anything else?
Inequality in power.
Inequality in power. Awesome.
Receiving an unequal treatment.
Receiving unequal treatment. Absolutely.
Reduction and an impediment for opportunity based on a non-scientific or non-social reason.
So an impediment to participation or inclusion as a result of something arbitrary, something that...
Actually unscientifically proven. For example, discrimination against the gay community.
Oh, sure.
It's an obvious one.
Yeah.
Medical sciences here, people conjure up all kinds of ideas.
Right, right. So we don't have science to justify differential treatment, and people treat LGBTQ communities differently on the basis of things that have no grounding in fact. Thank you. Anything else? That's an awesome list. I think we've covered a lot of these, singling people out. Oh yeah.
How about like bias? Like we're talking about like a reduction in things or impediment to people being granted assistance or things. It can be based in like having medical knowledge, not having medical knowledge, but it must be based in bias, like societal bias or bias in the organization.
Totally.
Yeah.
Yeah, I agree. Biases,
Or
stereotypes, ignorance about a particular group that results in treating them badly, treating them differently. Discrimination might look like singling someone out for different treatment, excluding someone, same idea. Harassment and bullying can be discrimination as well. Gossiping can be discrimination as well. Name calling, violence. Great. In the law, we talk about two different kinds of discrimination. Direct discrimination, where someone is being treated badly. They're being treated in a way that causes them some disadvantage. And it's a really direct kind of transaction. A wrongdoer is doing something that excludes or punishes or singles out or treats badly someone else. So someone sexually harassing someone would be an example of direct discrimination. Someone treating someone badly on the basis of their sexual orientation or their race, not hiring someone because they are from a particular country. Examples of direct discrimination. Or because they're pregnant, yeah. Firing somebody because they're pregnant. Great example of direct discrimination, and surprisingly common. Indirect, or what's also sometimes called adverse effect discrimination, is sometimes harder to spot than direct discrimination. Direct discrimination can be a lot more straightforward. Not that it's easier to prove necessarily, but it's certainly, I think, we feel it more, we see it happen, we know that it's wrong. Whereas adverse effect discrimination is the kind of discrimination that can kind of fly under the radar if we're not looking for it. It's where there are policies or requirements or practices or qualifications which don't look discriminatory on their face, but result in exclusion or disadvantage. I bet if we took a pause, and which I won't do, although I'm tempted to because I really like it when people participate, but I bet folks could think of examples of adverse effect discrimination that they have seen in their own lives. The design of a form, the design of a building, a particular requirement or standard that, until you look deeper at it, you don't realize may have a discriminatory impact. The kind of classic case, an actual case, where this concept was sort of grappled with, well, there are a few. I'll talk about one. Maybe I'll talk about two. One was a really old case from the 80s, I think, where the employer had a policy of requiring its staff to be available to work 7 days a week. Not that they had to work 7 days a week, but it had to be available, right? And the employer would schedule the staff as he saw fit. And the complainant was a Seventh-day Adventist, and she could not work on Saturdays because it was the Sabbath, and her religion required her not to work on Saturdays, and she told her employer this, and the employer said, well, sorry, this is my policy. It's not discriminatory, it applies to everyone. On its face, it doesn't look discriminatory, right? It applies to everyone, and it's not singling out people intentionally and saying no Seventh-day Adventists can work here, which would be direct discrimination, but the impact, the result, is exclusion or disadvantage for this individual who can't work on Saturdays because of her religion. Clearish? Okay. So who is protected by the Human Rights Code? Everyone is protected by the Human Rights Code. Doesn't matter if you are not a citizen, if you don't have PR status, if your work is temporary or on contract, if you're a volunteer or an unpaid intern, or you work part-time. Everybody has protections under the Human Rights Code. Where are we protected? I think I've said this a few times. We're protected in our jobs and in our homes, whether we're renting or attempting to purchase property. And we're also protected in our access to services and facilities. And this is probably the biggest category, the biggest bucket of things that we might put different kinds of interactions from our day-to-day life into. So when we go into a business, we try to access a community center, we go to a hotel or a bed and breakfast, schools, government services. These are all examples of services. The language of the Human Rights Code is services customarily available to the public, where discrimination is not allowed. So this is where we're protected from discrimination. And we've talked a bit about what discrimination might look like in terms of the sort of personal characteristics that each of us has that are prohibited, that we can't be discriminated on the basis of. So we heard sexual orientation already. The example I just gave was about religion. disability is a protected characteristic. This is the list of protected characteristics. These are grounds that are prohibited from, people are prohibited from discriminating on the basis of. It's not a very grammatical sentence, but I think you get my drift. So race, color, ancestry, place of origin, all fairly similar. Go to a person's ethnic origin. Religion, we've talked about marital status or family status, who's in your family, what kind of family you have, are you a single mom, and the landlord doesn't want single mother-led families in their apartment building, physical or mental disability, sex or gender, sexual orientation, gender identity and gender expression is the newest protected characteristic that's been added to the Human Rights Code. BC added that ground a couple of years ago now, a little bit slow compared to the rest of the country, but happy to report we do now have explicit protection for trans individuals in our Human Rights Code. Age is protected, although only for folks 19 or older. Lawful source of income is protected, but only in relation to tenancy, so a landlord can't discriminate on the basis that you receive welfare or disability. And a criminal conviction that's not related to the job is protected in the employment context. So it's a bit of a laundry list. Not going to say too much more about the various different grounds, and we'll focus mainly on the grounds of disability. I'll say a little bit more about those. What is a physical disability for the purposes of the code? Well, happily, it's defined very broadly. It's defined to be an involuntary condition or situation that a person is dealing with that is severe and either permanent or persistent. It is something that impairs a person's ability to carry out the normal functions of everyday life. It impedes participation perhaps in the workplace or in other in other areas of life. And there's no list. There's no list of like, these things are a disability and these things are not a disability. It's an open category, and provided that the condition or issue that the person is dealing with kind of checks those boxes of being involuntary, severe in nature, which of course is a continuum all its own, and permanent or persistent in nature, it will likely be found to constitute a disability for the purposes of BC's human rights law. It's a case-by-case assessment. Mental disabilities, same kind of thing, broadly understood to include mental, cognitive, and intellectual conditions that may affect a person's abilities or that are perceived to affect a person's abilities. We know that sometimes people face discrimination on the basis of bias, on the basis of stigma, not necessarily on the basis of any actual impediment that they might have, but on the basis of stereotypes about what they may be capable of. Learning disorders and developmental disabilities they constitute mental disabilities for the purposes of BC's human rights law, as do mental illnesses.
So I'm kind of curious about that, because I remember that in the form for rather physical disability and mental disability.
Yeah.
And for ME, it's
kind of both.
Say it's both. But
Totally.
you can only choose one, like, does it?
No, it is not both. It is physical.
Yeah,
It's
totally.
a neuroimmunological disease.
Totally, 100%. But there's cognitive.
But that's neuroimmunological. It's not mental disability as such.
Yeah, but I'm just curious how it would be listed on that. Like, when you fill out the form for the Human Rights Tribunal.
You are 100% allowed to tick off more than one box, because discrimination doesn't necessarily happen one protected characteristic at a time. We are an intersection of all of these various characteristics all at the same time. And we know that racialized women with disabilities have a different experience than perhaps a white man with a disability. We know that adding pregnancy or the inability to speak English is going to change your experience of discrimination. So discrimination can happen on multiple and overlapping grounds at the same time. You might look at what happened to you and identify that it wasn't just your disability that was at play, but it was also your gender, for example, or your sexual orientation. So you are absolutely entitled to check off all of the boxes that apply. Yeah. I could give examples on all this stuff, but let's just keep moving forward. I found a few cases that dealt with, they refer to it in the cases as fibromyalgia, as well as chronic fatigue syndrome. So I just want to show you those quotes and show you the cases that they come from. The little phrase at the bottom is the name of the case that this quote comes from, and the tribunal, BC Human Rights Tribunal, that's what BC HRT means there at the bottom, said there is no dispute that Ms. Kitabchi has fibromyalgia, that fibromyalgia is a disability within the meaning of the code, and that Future Shop, her employer, had a duty to accommodate her for that disability. So there's no fight, there's no question that fibromyalgia is a disability and constitutes a disability for the purposes of human rights law. This is a much older case, 2001, from Ontario. This individual had reactive depression and chronic fatigue syndrome, and the language that they used at that time was the language of a handicap as opposed to a disability, but nevertheless, these were clearly found to constitute disabilities for the purposes of the Code of Human Rights Protection. I also found this, I think, very helpful from a pretty recent case against BC Hydro related to the smart meters. Now, the case wasn't successful ultimately, but I think these are some important quotes to take away that help highlight the tribunal's broad understanding of what a disability is and what it means to have a disability for the purposes of the code. First of all, and I've just put dots because this was a big chunk of text and I just pulled out the parts that were most relevant. A medical label is not necessarily required to establish a disability. These were individuals who were claiming to have sensitivity to the electromagnetic frequency of the smart meters and suffered a range of symptoms as a result of that condition. And there was dispute in the medical evidence about whether that really was a disability at all. But what the tribunal says is a medical label is not necessarily required to establish a disability. A distinction should be drawn between the question of whether a disability exists and the question of whether medical science has a label for it or has determined its cause. Legitimate, demonstrable physiological symptoms should not be ignored as a disability under human rights legislation merely because a concrete medical diagnosis is not yet available. On the other hand, it is conceivable that, as advanced by BC Hydro, such symptoms will never be able to add up to a medical diagnosis, but rather are a patchwork of symptoms reliant on the personal experience of a variety of citizens. And they may well have a disability for the purposes of human rights law, despite the fact that the medical science, medical research hasn't been able to put its finger on exactly what that means or what that looks like. So I hope that that's helpful. I'm no expert at all on ME or FM, but it strikes me that there may be some overlap here in terms of the symptoms, the difficulty of accessing a diagnosis for some individuals, which nevertheless does not undermine the fact that serious and significant symptoms are present. So remember this case. In terms of who can be named in a human rights complaint as responsible for discrimination, most cases are brought against employers. Probably about half, if not more, of the complaints that the tribunal receives are complaints against an employer. Second most is landlords. A business owner may be named. Government ministries can absolutely be named for having discriminatory policies or practices in place. Other service providers can be named. Doctors, nurses, healthcare staff can be named. Generally, individuals like that are named in situations of direct discrimination, right? If a nurse, a specific nurse, is discriminatory towards you, treats you badly on the basis of one of those protected characteristics, like your race or your disability or whatever it happens to be, you might name that individual. If they're personally responsible for what happened. Generally, the institution is held liable for discrimination, which is usually good because they often have the deeper pockets and the ability to compensate a person for the discrimination that happened. But if somebody is acting outside their duties, like in a sexual harassment situation, for example, we often see individuals held responsible for that kind of behavior, because why should the employer have to compensate when it was one individual who was behaving badly, not acting within the scope of their duties, and behaving inappropriately? That said, employers do have the obligation to ensure that they're providing a discrimination-free workplace. So even if they're not the ones doing the discrimination, but they're failing to take action about discrimination that they know about, even if that discrimination, again, I think sexual harassment's a great example, is coming from customers. If customers are sexually harassing the staff and employers don't do anything about it, they could be liable for that behavior. So, yes, please. Sure.
So if as a patient you are being denied care because you have like a doctor that does not take new patients, but knowing that we have any, they certainly do not want to. Like it may happen, and I hear that a lot, that doctors want only the healthy people. The babies here.
Yeah, great question. So to make your human rights complaint, you have to show three things, basically. You do. And then the respondent has things they have to show to try to justify that conduct. So you have to show that you have a protected characteristic. You have a disability. In many cases, that is fairly straightforward. Often the respondent doesn't even challenge whether you have a disability or not. You have ME, okay, you have your disability. You have to show, the second thing you have to show is that you were treated badly. There was an adverse effect on you, a negative effect. Something happened to you that was negative for you. So being denied the care of a doctor, negative effect, check. But the third thing that you have to show, and it's the third bullet point here as well, how are they connected? What is, the language of human rights law is nexus. What is the nexus between your disability and the negative treatment? Now, if you have evidence that the doctor's taken in new patients all over the place, but when you got there and disclosed that you have ME, she didn't take you, then maybe you'll be able to establish that connection. But if the doctor just isn't taking new patients at all and is turning away people with all sorts of different illnesses and disabilities, you might not be able to show that your disability was a factor in that denial of service. Does that make sense? So that third piece, showing the connection, is always the hardest thing. It's in, I would say, 90% of the cases, it's the piece of the analysis that is most contested and hard fought. And it's the hardest thing to do as a complainant because you don't have access to the information that you need. Most discrimination does happen quietly under the radar, right? Sometimes you have, a person that goes on a racist diatribe or says something very overtly discriminatory, but much more often, it's a lot more subtle, isn't it? It's biases, it's stereotypes, it's things happening under the radar that can be very difficult to prove. So I want to acknowledge that, right? That engaging the litigation process is a big undertaking, and it's hard because you have to not just believe that you were treated badly, but be able to prove on what's called the balance of probabilities. It's more likely than not, convincing the tribunal that what happened was connected to your disability or to some other protected characteristic. Yeah. Yeah.
Can I just add a comment there?
Please.
Because I've looked a bit at this. There are a number of college policies that give doctors not only the right but the obligation to turn away patients if the practices are full. So there are some very legitimate reasons for doctors to turn people away. And I've been turned down by doctors, and I didn't have an issue with it. I've been turned down by other doctors, and was treated in a manner that I do have an issue with it. So I saw a number of doctors, and yet I filed a complaint, and it's not all of them, because a number of them have legitimate reasons, and were not behaving in a high-handed manner, and have not made comments about having a complicated illness and not being fast enough or quick enough.
Did you also have a question or a comment?
What if it is something that they're not doing on purpose? Like, for example, I've had to change dentists now twice because they're allowing pets into their office, and I have serious pet dander allergies, and I'm really quite ill whenever I go. And so I asked just last week about our pet policy, and they said, oh, not everybody here has a pet on staff even. And so I went in the washroom, and when I was in there, they were laughing at me. And they were very quiet when I came out because they didn't realize I had gone into the washroom. They thought I had left.
Right.
So they were actually mocking me behind my back. And they didn't even respectfully listen to the fact that they're allowing pets there.
Right.
Is having a major effect on me.
Yeah.
And I have to keep on changing dentists because more and more medical offices are allowing people to bring pets, and they take their pets to work.
Right, right. Thank you for your question. For those that are listening online and probably didn't catch that, the question was about dentists, and this is probably the case in other services as well that people are dealing with where pets are present. I know there are a few pets at my workplace too, and so far that hasn't been an issue, but there are folks for whom the presence of animals and animal dander, they have allergies or serious reactions to the presence of those animals. If it's okay with you, I'm just gonna put your question right here and come back to it when we get into the next concept, which is called the duty to accommodate. Yeah.
Can we add to that with Mark?
Yes.
Two more points. One
Sure.
would be people with chemical sensitivities,
Yep.
right? So fragrance.
Yep.
Because there's similar stigma to people not understanding. And then people that have sensitivity to electronics.
Yes.
Also a group of people that desperately need some understanding and compassion and ability to interface with again services, service providers, medical providers, similar barriers.
Great. Yeah, for sure. For sure. Those are all great examples to talk about when we talk about duty to accommodate in just a moment. I just skipped ahead a couple of slides because I feel like this is what is the most important for us to cover. We talked about the three things the complainant has to show: their protected characteristic, a negative impact or negative treatment, and then a connection, the nexus between those two things. If a complainant is successful in doing that, the case goes then over to the respondent to try to show that the treatment was justified, there was a reasonable explanation, just like the examples that Angela gave. The doctor's practice is full, for example. There's a policy that requires doctors to turn patients away if they're already oversubscribed. That would be a potentially reasonable explanation, a non-discriminatory explanation for that negative thing that happened to you. You didn't get the service that you wanted. But if they were able to show that that was true, then they would be successful in saying, well, it wasn't because of your disability. In the employment context, employers may also be able to show that the standard or the requirement is what's called a bona fide requirement of the job. So as a sort of perhaps obvious example, it's a bona fide occupational requirement that pilots have 20/20 vision, for example. It's legitimate to require that. It does have a negative impact on people with visual impairments, but given the sort of balancing of interests and the nature of the job of an airline pilot, most people would agree that it's reasonable to require that particular standard in that particular case. So I want to spend my last 5 minutes, if I can, talking about the duty to accommodate. Employers, landlords, service providers all have a duty to accommodate people with disabilities. And that duty to accommodate is up to what's called the point of undue hardship. You have to accommodate a person to the point of undue hardship. So you can imagine that that's also a very contested term, a contested idea. What is an undue hardship? But just before we get there, I want to just go through a couple of these slides about the importance of accommodation for promoting, remember those purposes of the code, that like high language, beautiful language about addressing persistent patterns of inequality, addressing systemic injustice? Well, accommodation is about those things, because treating people the same doesn't necessarily bring about equality, right? We're not the same. And so treating us all as if we're equal is actually going to just reinforce and perpetuate, continue existing patterns of inequality and discrimination. We have to look to outcomes. We have to look to results and take into account people's actual needs, actual characteristics. And there are lots of cases about how accommodation is actually the essence of equality. And it requires positive steps, actual action on the part of employers and service providers and others to promote equality, to take steps, to do things differently so that people can actually enjoy equality. And one of my favorite quotes is from a case from the Supreme Court of Canada called Eaton. It's from 1997. And what I love about this quote is that it reminds us that the disabling factors that create inequality are often factors created by the environment, or that exist in the environment, right? It's the failure to make reasonable accommodation, to fine-tune society, to make changes to its structures and assumptions so that they do not result in the relegation and banishment of disabled people from participation, right? We actually have to build the ramp so that spaces are accessible to people who use wheelchairs. We actually have to create the braille buttons in the elevators so that the elevators are accessible to people who are vision impaired. It's not their vision impairment that's disabling, it's the fact that the environment doesn't accommodate their needs, doesn't take into account their difference and respond to it. Maybe you've seen this image. I love this image for its illustration of the difference between a sort of impoverished view of equality, where we just treat everyone the same but don't care too much about the outcome, and where we treat people differently because they are different, and we prioritize the outcome of equality. Everybody gets to see the baseball game, and the tall kid doesn't need a box. Short kid needs 2 boxes, needs a little extra, if the result of what we're going for is equality. Treating everyone the same actually reinforces disadvantage. Treat everybody the same in this example, and the short kid still can't see the baseball game. I have just some slides here about the economic arguments in favor of accessibility. Study after study after study is showing that when employers provide accommodations for their workers, ensure that workers who are there and want to work can actually do the job with some support, the economic benefits for that company are massive. They don't lose money in productivity loss and employee turnover. They put a little investment into adjusting the workplace to accommodate a person's needs, and the gains that come back to them are far more than the cost of providing that accommodation. And research is showing that there are lots of folks who would be working or would be working more than they currently are if their employer was willing to provide the accommodations that they need. So I'm just going to say a few more things about the duty to accommodate. And these slides refer to employers, but the duty to accommodate, as I've said, applies to service providers. It applies to dentists' offices, doctors' offices, community centers, landlords, strata corporations, all have a duty to accommodate people who are accessing their services or employed in those spaces, up to the point of undue hardship. Again, it's a case-by-case approach. The employer or the service provider has to give serious consideration to how the person can be accommodated. And both parties have to be involved. You can't just say, I need an accommodation, and expect the employer to know what to do. Very often, a person with a disability is pretty expert on what they need in order to participate and engage, and needs to be involved in requesting accommodations, making suggestions about what is going to work for them. Now, a reasonable accommodation doesn't necessarily look like a perfect accommodation. It relates to what people actually need, not, what they would really like to have, but it does impose, I'm just gonna skip over this, sorry, because I'm running out of time. It does impose an obligation to do something, to take positive steps to meet the employee's needs. And as I've said, the requirement is to accommodate to the point of undue hardship. And undue hardship means that they may have to incur some hardship. That use of the word undue is very intentional. It's very important. The point, if you imagine like accommodation as like a, what do you call one of these things? Like a meter. And so an employer has a duty to accommodate to the point of undue hardship. Maybe that's where undue hardship is. And beyond that, it would be unreasonable to ask the employer to do more. But all through here, the employer is doing things. It's taking steps, it's maybe spending money, it's maybe adjusting the layout of the workplace, it's maybe purchasing a particular kind of technology to accommodate the needs of the person with the disability. So they may have to incur some, I don't even think it's right to use the word hardship in this case, but some cost, some time investment in providing the accommodation. It might involve expense, it might involve a bit of convenience, a bit of disruption. And all of that is reasonable until it reaches the point of undue hardship. And that burden is always on the employer or the service provider. So in the dentist example, I think that, the issue would be like, is it an undue hardship for you to, for the employer, I should say, is it an undue hardship for the dentist to not have dogs in the office on the days that you come for your appointment? And what does that accommodation process look like? Well, it would involve making the dentist aware of your disability or your sensitivity. Perhaps that might include providing some medical information to them and asking for what you need. Now, I'm not saying it would be enough that the dogs wouldn't be there on the day that you come in, because I can appreciate like dog hair remains in the office. So what is it that you need? And is it reasonable in the circumstances to request or require that? And what can the dentist do? Maybe the dentist can ensure that the dentist office is very well cleaned the night before a person with an allergy or sensitivity attends for their appointment. Maybe they can ask people to ensure that they're wearing a clean sweater or clean scrubs that haven't interacted with a dog in the past. For scent sensitivities, right? What can the employer do to accommodate the employee's needs? They have to do something. The person has a real disability, a real sensitivity to the scent. So what's triggering them? Can we change the soap? Can we implement a policy and post it everywhere and send an email to all of the staff letting them know that there's a scent-free policy? Do the cleaning products that get used need to be changed? Like, what's going on and what can be done? And you know, those are things, those examples I think are things sort of on the lower end of the undue hardship meter, but it can go all the way up to, I mean, putting in place an air filtration system to deal with the scents in a particular workplace. Maybe it means that the employee has to be transferred to another location because there just isn't any way to get around the scent of the off-gassing carpets that just got installed. And the employee just can't work in this place anymore and needs to be transferred to another location. Where the undue hardship kind of line is depends on a variety of different factors. It depends largely, I would say, in most cases, the most significant factor is the size of the operation. So a giant employer with offices all over town and 1,000 employees, it's going to be a lot easier for them to, number one, spend the money that it might cost to put in place the air filtration system, for example. It's going to be easier for them to transfer employees or maybe reconceptualize your job altogether, right? That's a lot easier for a big company to do as compared to a company with one location and just a couple of staff. So those are I'd say that's the biggest factor in terms of deciding where the undue hardship kind of threshold exists. Safety and risk, that's going to be a significant factor as well. I've gone a little bit over the time that I had hoped to go, but I want to just show you one more slide about the duty to accommodate. Because I think this is important. Accommodation is a process, an ongoing process, more than it is a set result at the end of the day. This obligation to accommodate means to have conversations, to investigate what is possible, what is the person's needs, and what can be done to meet those needs, with the goal always being to support the person to participate, whether as an employee or in their access to the service, to the greatest extent possible. And it is a balancing, sometimes, of competing rights and interests. We see this come up with animals a lot, actually. People who use service dogs wanting to access a dentist, and the dentist actually being like, no, we can't have an animal in the dental office or in a restaurant. So it's about balancing competing considerations and trying to fit those together so that everyone's needs and interests are protected to the greatest extent possible. And I like this idea of it being a continuum. Like, best case scenario is that the accommodation provided is perfect, gives the person exactly what they need, respects their dignity, respects their autonomy, respects their full participation. But that may not be possible right away. And so there are sort of other steps down the line that are part of the continuum of accommodation. Maybe they're a first step. We'll get this in place temporarily. We'll send information around about the need for people to not wear perfume at work. and ultimately we'll hope to save up to put in that air filtration system next year, but we're just not able to do it right now. So it may be something like that. It may be a sort of step-by-step process, but always the invitation should be to stay in conversation, to continue to work together to figure out what can be done to best support the person's needs. So I would love to spend the next few minutes, or as long as you would like, in discussion and with questions. Yeah.
All my questions is quite simple, but just read the limitation period of 6 months. It's pretty short.
Mm-hmm.
The date the actual discrimination occurred, or the date of the realization that the damage has occurred as a result of the discrimination?
That's a great question. It is from the date the discrimination occurred. And I'm just, I think I might have passed.
How did they come up with such a short limitation period?
There it is. Yeah, it's outrageously short. It's much too short. Even a year is pretty short, but I hope that that's what we're gonna at least get back to. Most, if not all, I don't think any other province has 6 months. Most have a year. And 1 or 2 provinces might even have 2 years, but a year is standard. And the 6 months was brought in the early 2000s. At the same time, the Human Rights Commission was cut, and I think it was just a way of narrowing the number of complaints.
That's subject to the discrimination to either party. Prejudice to either party.
So the reason for a 6-month timeline is to not prejudice the respondent, right? You can appreciate that there probably has to be some deadline, because if people were allowed to bring complaints about things that happened 10 years ago, for example, it can be really difficult to advance those cases, but also to defend them, right? Witnesses have maybe moved away or passed away or don't remember, documents have been lost or destroyed. Like, it just isn't really realistic to litigate a case about something that happened 10 years ago. But 6 months is very short. And I will take us back to my slide about the 10-month or the 6-month deadline and talk about an exception to that, because oftentimes discrimination is continuing, right? There's a policy in place that has ongoing discriminatory impacts. And we talk about this with the word or the phrase, a continuing contravention. So if discrimination keeps happening time after time, every time you go to the doctor, you are treated badly because of your ME, and it happens time and time again, sort of similar instances, similar kinds of treatment by the same doctor, time after time, and it's been going on for 5 years. You could probably bring in those older instances of discrimination to your complaint, even though they happened 5 years ago, provided that it's continued to happen and it most recently happened within the last 6 months. Does that make sense? So that's the first kind of continuing contravention, a repeated act of a similar character. There's also a continued state of affairs kind of discrimination situation. So an example would be, I've lived at this building for 10 years. I started using a wheelchair 4 years ago, and it doesn't have a ramp, and it still doesn't have a ramp, and 4 years have gone by, and it still doesn't have a ramp today. So you can talk about the impact of that 4 years of needing a ramp and not having access to one. Or a policy, for example, could be challenged even though it's been in operation for a long time, provided that you have some kind of recent event to anchor the discrimination, then those older events can kind of come in. Did you have a question? Mm-hmm.
I'm just reading from people online.
Awesome.
So one question was, can we bring a human rights complaint against a federal government policy?
You can bring a human rights complaint against a federal government policy, but you would bring it to, does anybody remember? The Canadian Human Rights Tribunal. Back at the beginning of the presentation, I had the side-by-side. There was a Canada flag and a BC outline of the province. And so I didn't talk very much about the Canadian Human Rights Tribunal, but when it's a federal law, federal policy, federal ministry, or federally regulated employer, like a bank or an airline, for whatever reason, those are federally regulated. Interprovincial trucking companies, transportation companies are also federally regulated. Your complaint would go to the federal system, the Canadian Human Rights Tribunal and the Canadian Human Rights Commission, which does the first level of investigation. Thanks for that. Do you have another one?
Yeah.
Oh.
The next question is, have there been any human rights cases against Handy Dart?
Yes, there have, but I'm afraid I don't know the details of them. But I am aware that there are real concerns with Handy Dart's level of service, and I am aware that human rights complaints have been made against it, but I'm afraid I don't know the outcome. I should say that the vast majority of human rights complaints are settled. They are resolved by the parties without a hearing, either generally through that mediation, the free mediation that the tribunal provides that I mentioned. The tribunal is very proud of its high settlement rate, and really very few cases proceed all the way to a hearing. Yeah.
Where is there public record for someone that was inquiring about that? How can they find out information about cases?
Thank you for that. That's a great question. There are two places where you can find, for free, human rights decisions. The first is the Human Rights Tribunal's website, bchrt.com. It's not my favorite place to look for cases because the search function just isn't very advanced, but a great resource for finding cases is called CANLI, CANLII, and it's a database of all sorts of legal decisions, not just the Human Rights Tribunal, but you can kind of hone in. You can choose like just BC, and then within that you can choose just Human Rights Tribunal, and then you could punch into the field for the case name Handy Dart, and all of the cases where Handy Dart was a party would pop up.
So if someone were to have a case and permit the tribunal to bring it to settlement, do the settlement results end up in Canada?
No.
Only ones that go to tribunal?
Only ones that go to a hearing. Settlement results are generally confidential, and they usually happen at an early stage in the process, so nothing has been made public yet. At least it hasn't been made public by the tribunal yet. Some people, when they file their case, they make a media statement, for example, and so there is some public awareness of the fact the case has been advanced, but most of the time the settlements that the parties negotiate are confidential. Yeah.
Next year I have a BC Human Rights Tribunal hearing, and there's a few things you have to show for a case.
Yeah.
So that's easy for me to show, and also you have to show that the employer didn't go to hardship.
Yeah.
That's even easier to show.
Oh, good.
So I believe I have all those things. That's good. But the issue I have is I'm trying to get more data from the employer, and that employer is sending false information. I believe it's easy to show that that's false. But I'm just wondering, like, I have all these three things. I have the undue hardship. Like, what's the benefit of me going to all this extra effort to get to show to the extreme lengths that they've gone to how can I say, to hide the truth, I guess. I'm wondering, is it worth my effort? Like, what's the benefit of showing the lengths that the employer is going to avoid, having the truth shown in this case?
I mean, when you go to hearing, you want to advance every possible angle and every possible argument. So I wouldn't necessarily look at it as like you're trying to show the lengths that they've gone to avoid compensating you, but rather you want to show that whatever their explanation is, whatever their justifications are are not legitimate. They're not bona fide. They're not reasonable. And the tribunal will draw its own conclusions about their behavior.
That is basically just denial. So it's kind of like, I feel like my case can just denial. The other side hasn't really.
That's generally how they go, right? Like the Human Rights Tribunal process, other than when you're in settlement negotiations, which is an attempt at something a bit more collaborative, but as it moves forward, it's adversarial, right? It's two sides that get entrenched in their position and are gonna, are unlikely, unfortunately, to compromise on that. So I'm not surprised to hear that that's the tack that they're taking, just deny everything. But it, provided that you have the evidence that you need to show those three things, and they're not able to show accommodation to the point of undue hardship, it sounds like you'll be okay.
For you. Thanks for sharing that. Do you have Emmy or FM?
Yeah.
Right. And so how exhausting and how long has this process been? Because there'll be people who will be listening in who will be thinking, is this for me? So just wondering, how many spoons do you have to use for something like this? And sorry, just for the people, can they hear that question? So that
I doubt it.
You know what, I've got one right here. So my question is to the gentleman who's got the Human Rights Tribunal case coming up next year. How long has the process been, and how many spoons did he have to use?
I don't really use the spoon analogy, but yeah, it's
Just energy. It's a symbol for energy that people use.
yeah, it's just, maybe you have 10 spoons each day for energy, and if you, it totally depends on the person, but for one person, for example, going to the bathroom might be 1 spoon. And if you, the more you do, like the worse you get kind of thing. I mean, it's quite variable. But anyways, getting back to the question. So I guess I filed the thing in March of last year. That was a 6-month deadline after the discrimination. So I did it by then. And, so 6 months I tried to get a response, and my employer, they never negotiated. They never contacted me. Is all like, I'd call them, they wouldn't call back. I'd email them, they wouldn't email back. Just really, really silly. So in March of last year, that's when I filed the thing. And then the actual date of the hearing is May 14th next year. So what does that make it? So March 2007, sorry.
Just
Yeah, I
over
guess
2
so.
years, yeah.
Or sorry, it's March this year. Okay, my bad. March 2018 to May of 2019 will be the length of the process.
Okay, and that was with no mediation?
So the mediation, I did not like the thing about how it's, sorry, I forget the word, like the NDA thing,
Confidential?
Yes,
and,
I
yeah.
really didn't like that at all, because
Okay.
with ME, we're like discriminated against so much, and it's basically like, shut up, sit down. So for me, that really bothered me that the human rights organization was like that. It's, let's just quiet it down. Like I didn't think that was human rights at all. It's basically, go back in your place. So that's just my personal thoughts on that.
Yeah. I've put up a slide
Yes.
here just for your reference, setting out the timeline. So when there is no early settlement meeting, the mediation, you could shave about 4 months off the hearing process. And then it sounds like in your case, there also wasn't an application to dismiss the case. There is an application to dismiss in many situations, and that adds time to the complaint process as well. So I think that if you added up that timeline, you're probably looking at close to 2 years from beginning to end. And depending on the complexity of the case, how long the hearing takes, how long the tribunal member takes to decide, it certainly could be more. It's great to hear that you're getting to hearing within about a year. I would say that that is on the shorter end of things, and often it's closer to 2, if not longer. Yeah.
Just in addition to the question
So I should,
Wondering how to approach it.
yeah, I can't give legal advice about a specific situation in a context like this, but
The question is, how do we approach the situation?
yeah. What I would invite is for anyone who wants to talk through their own specific situation to have a look at our clinic's website and look at the drop-in clinic option. It is an in-person drop-in where you can have 30 minutes of advice and information with a lawyer or an advocate. If coming in person on a Monday is not possible for you, and I appreciate there are lots of reasons why there might be barriers to doing that, we'd be happy to arrange a similar style of free half-hour consultation with you by phone or in some other format that works for you. Yeah.
And Elizabeth, you had brought up that question of like how many spoons. So like I've been pursuing my own things, right? And there's the issue of how many spoons or how many units of energy or how much devotion or time or resources do you put towards, you know, human rights. And you brought up the issue of settlement. I have the exact same thing. Like I even feel like when I was in touch with the class that there was even discrimination on that. Like if they have policies around who gets support, how much support, and part of it is based in whether or not you're willing to sign a non-disclosure agreement. And I have the exact same sentiments: is that Emmy is not well known. It needs so much more exposure. The last thing I would ever do would be to sign a non-disclosure to not have things like the things you put up, like those cases. Like we need quotes like that. Like this person has Emmy, this person has fibro. They need X, Y, Z. Like we need those quotes for everyone's access, so that everyone can use it legally. So like I can understand that. But to answer specifically Elizabeth's question is like how much energy. It's like personally I'm facing like well many people are facing discrimination of not having enough access to either medical resources or support, and it's systemic. So you can look at how much energy does it cost you to engage in this process, but also how much energy does it cost you over the course of your lifetime to not have access to the resources that you need. And it's this scale, right? Like do you put energy in now? Can you afford it? Do you have the health for it? Do you have the mental health for it? What will it cost you versus what will it cost you to like not put in? Like, and those decisions will be personal, but
Yeah.
but looking at both sides of that, not just one side, not just the side of can I do this, should I do this, how much will it cost me in energy, but like what else do you need out of it? Like the balance I think is key, not just one side.
Thank you. Mm-hmm.
If I can just add to that conversation, I too have an active human rights complaint. My name's Angela. I've been a lawyer for 30 years. So I brought the human rights complaint knowing what the process was and for a certain goal. And when I phoned the tribunal to get some information, when I said doctor, they kept saying to me, malpractice, you want a malpractice case? Well, I'm a lawyer. I know I don't want a malpractice case. I knew that my goal was not to get money from those doctors. My goal was to get proper treatment. And as with a lot of us, once you have a doctor or a clinic that's supposed to be looking after you, that has the obligation under the policies of the college, you're kind of stuck there. I've been looking for a new doctor for over a year. So my choice, just as you were saying, was about if I allow this to continue, and I was being told I couldn't set appointments. I was finding myself having to meet with people who didn't believe in the illness and who were incredibly dismissive and vicious and not protecting my privacy. And so I had to make a choice. So I did file a human rights complaint. I didn't want to sue in BC Supreme Court. My energy won't allow that. And the money's going to do me no good if I'm dead. So what I want is medical services. So my complaint, using some of the information that Laura has been referring to, what I'm asking for accommodations is the ability to make appointments, is disclosure of which doctors in the clinic are familiar with ME, is disclosure of which doctors in the clinic are willing to put a phone call into the CCPP. There's a physician support line, physicians are get us help. So all I want is, I don't need to know you're a genius, doctor. Will you phone the people? Do you believe, are you willing to engage with me? And I want to make an appointment. I was told that I would have to come stand in line at 6 o'clock in the morning to get on the list for the day, go home and come back. I can't stand for 2 hours. I can't barely stand for 2 minutes. So I want to not stand in line. So I really thought about what I wanted. And I want to go through the free mediation. There's been a lot of discussion about, gosh, I wouldn't sign anything. Well, if I were going to trial, that would have splashed that all over the world. There's no doubt about that. But in a mediation, having been a lawyer for 30 years, every mediation I've ever done, you agree at the beginning that anything that's said there is confidential. So I personally don't have a problem with the non-disclosure of what happens in mediation. It's not non-disclosure of what happens to me. So I hope that that sort of ties into some of the issues that Laura raised. Just be careful with the phone when you say doctor. Don't let them tell you you need a medical malpractice. And as you say, think about where am I going? And for me, it's medical care. I need respectful medical care. And that's all I'm looking for now.
Thanks.
Sorry, I just realized now you didn't have the microphone.
Sorry.
Can you summarize that?
The brief summary for the people who couldn't hear me, I'm sorry, was that I have filed a human rights complaint. It is against a doctor who treated me disrespectfully and in a manner that I believe showed that she did not believe in my illness. It is also against the clinic who refused to, first of all, refused to allow me to make appointments so that I could get services. When I approached them, my own family doctor was away, so I asked who there would be willing to treat someone with ME. I was told I would have to come back and get in line, give my name, go home, come back later in the day to see every doctor in the clinic to ask them about their knowledge of ME, that the clinic would not respond to that. So I ended up filing the complaint. I did not want to go to court. It's not about money, it's about getting medical services. And so what I'm asking for is the ability to make an appointment, an obligation on their part to disclose who knows anything about ME, what kind of training each of their doctors has, and an indication that those doctors are willing to work with the CCDP and use the physician support line. So I really was targeting it at how do I get medical services, because I have tried for a year to get other services. I've been turned down by those doctors. I'm not complaining against them. Their practices are full. They would have taken me on if they could. They can't. That's a reality. So I'm trying to deal with the realities in that manner.
This is actually for Elizabeth, but is there a list somewhere of all the doctors who are aware of these illnesses and willing to see us? Because that's what we need.
I was talking in the AGM about the doctors database that we've been trying to create. And so it's a complicated process to create an online platform where people can input information. There is no way we could possibly ever know except with patients sharing the knowledge that they have. So that's why we wanted to do a BC-based database that is somewhere where everybody can just input. I've gone to Dr. Joe Blow, good with ME, doesn't know anything about ME, but good with forms, doesn't know anything about forms, but good with picking up the phone and calling the CCDP, you know, whatever it is. And so sharing the information between us so that we can create a database of information, it'll have to come from the community. There is no way of knowing that at all. It's impossible. But I can tell you there's an absolute severe shortage of doctors that do know about ME.
I just want to make a comment and maybe you can answer something, but I think that as a group, it is safe to say that patients with ME and FM face systemic discrimination in healthcare. And it is just so hard to try to find help and ways to break that barrier. We are of course, facing a doctor shortage, but it's even worse to have doctors who actually believe in the disease and willing to treat. Where do you start?
I think you start right here. I think this is the start, right? Having these conversations amongst yourselves, realizing that you're not alone, that you're facing the same kinds of issues over and over again, and that while each individual situation might look a little bit different, as you say, the issue is a systemic one.
And would that be something that if we wanted to have a consultation, like would that be a valid reason?
It would. I mean, a half-hour consultation on the launch of a systemic lawsuit is, you know, perhaps not sufficient. And there are human rights lawyers out there who, you know, aren't nonprofits, who aren't, you know, trying to provide as much service to as many people as possible, and could actually work with you on a more one-on-one, long-term basis to advance a case like that. Not to say that the clinic doesn't ever do systemic cases, but we're really limited in what we can do. And the front-end work of bringing people together, drafting a complaint, filing a complaint, that's actually out of our mandate. Our mandate kicks in once people have filed human rights complaints and have them before the tribunal. So yeah, I mean, and we don't limit the number of times people can come in for a half-hour consultation. So that, I mean, that is an option, but I think a much better option, if possible, and I recognize that lawyers are expensive, but I really think that if your goal is to advance a systemic complaint about the issues that you face, it's worth investing in somebody that can work with you through that whole process. Yeah.
Wouldn't that be the kind of situation where the lawyer is paid at the end?
Sorry, hold on.
If it's a class action discrimination against all people with ME and FM, etc., wouldn't the lawyer be paid at the end?
Different lawyers have different ways of doing things. There certainly are lawyers that will take on a human rights complaint on like a contingency basis like that, and depending on what the award is at the end of the day, they take a cut. As I mentioned, Human Rights Tribunal awards are not very high, so that can be something that lawyers aren't able to do because the amount that the tribunal is going to award you is not very much likely. But like I say, there are lawyers that do practice that way, but I think the majority probably would have an hourly fee.
You also need a named defendant. You can't just name the doctors or the medical profession. That's
BCH,
yeah, that's fine. What's BCH?
Vancouver Coastal Health.
But then there's also like, there's Irish Health, Fraser Health, and they all have the same, they're like sister organizations, very similar policies because they're under the same umbrella, which is Providence, right? So you can go up a level in that and go to the top, which is a lot of the initiative that we have right now about finding out. Like there's different ways to skin a cat.
But for something big like that, wouldn't the award be over 5,000? If it's a big class action?
It depends. It depends. The awards are never very, very high, or rarely very high. And in a class complaint, they're distributed amongst a whole group of individuals. So the total might be high, but each individual's award might not be that high. The most recent class complaint I can think of that went all the way through a hearing and had a remedy award was discrimination in the construction of the Canada Line subway. There were racialized workers that were paid substantially less and housed in substandard conditions as opposed to the white workers on that project. And and the awards that they were granted were $10,000 each. So, and they went through, you know, many months of discriminatory treatment and had a really terrible experience. And I don't know. I don't know how we all look at a dollar figure differently, but $10,000 doesn't seem like a huge amount to compensate for the harm that these individuals experienced.
If everybody works on the difficulties in society, then we can have a better country, right?
Yeah. And I mean, ideally, it doesn't require litigation to get there. That's sort of the worst option from my perspective. And I do this work. It's like the last resort for sure. If you can achieve your goals through advocacy, through lobbying, through media, through organizing, from my perspective, that's almost always preferable to engaging the legal system. Not just because of how long it takes, but there's risk, right? You might not win. You might not be able to establish to a legal standard that what's happening to you is contrary to the law. Might be wrong, might be terrible, might be unfair, but is it discrimination under the code? Like, the legal standard might look really different than what we think an inclusive and fair society would look like. Yeah.
So I just have two last questions here from online. The first one is, have any patients filed and won human rights cases against the provincially funded CCDP?
Not that I'm aware of, but that doesn't mean that it's not the case.
Okay. And then the next question is, the last one here is, are there any human rights that pertains to families?
To families?
Yeah.
There is. So family status is a protected characteristic. Here's our list of protected characteristics. We're protected from discrimination on the basis of this list of things, including family status. So family status means who's in your family. You can't be denied a service because the service provider doesn't like your husband or had a fight with your brother. The example that I gave earlier when we went through the laundry list was single mother-led households. We know that discrimination against single moms and single mother-led families is a real problem in services and in tenancy in particular. That would be contrary to the code. And family status might also include childcare obligations. This is a really interesting and kind of influx area of human rights law where employees are asking for accommodations for their need to provide care for their small children. And employers have an obligation to accommodate, to the point of undue hardship, an employee's childcare obligations to a certain extent. As I mentioned, the law is in a bit of flux on that question, but all of those elements are sort of captured in that family status characteristic. I hope that is helpful to the person asking the question.
I'm wondering how this human rights issue connects with Jennifer Bray's statement on her website that she and her group are working on suing the medical establishment for ignoring the countless people who happen to be invisible because they're at home and not giving them treatment.
I don't know anything about that. I can't speak to that directly. I don't know if anybody else can provide some insight. Okay. Yes.
That we are discriminated against due to this illness. So it's just not in BC, not just in Canada. It's
Right.
all around the world.
She's taking action in the States.
Yes.
Thank you for that. Okay.
There was a question that was brought up about, I think, Deborah, you were saying about wouldn't the settlement be large or would it be small? I think there's two things to consider is if the objective is settlement cash or if the objective is service that you need, or if the objective is to change a stigma, or if the objective is to provide education or systemic change. And like, we actually need all of that. And I appreciate what you were saying, that it's a global issue, right? And the number of parties involved includes everyone that's needing services and facing human rights discrimination, because it's a large number of us still to be counted. And then, I mean, some of the human rights cases that come to mind for me personally are the residential schools. I mean, you have people dealing with ME that are stuck at home, that have no access to medications, they have no access to food, they have no access to cleanliness, they have no access to communication and community. It's a form of cruelty to not assist them in some way. And I recognize that people that have chronic illness in general face those issues to varying degrees depending on the person. Everyone's unique, but if we were to look at how many people are in a position to even consider to create a human rights petition, it could be rather large. And the larger the case, the larger the settlement, and then where does the money go? It gets divided individually, or does it go towards creating an endowment fund or a training fund? Like, I mean, those, like you said earlier, this is the beginning of a discussion. It's not the end of a discussion, and certainly a lot of the questions we have, the answers aren't necessarily in the room, but it's a good beginning point. So,
I had a question to ask you to just clarify what you mean by what constitutes family status.
Okay. So family status means who's in your family or what kind of family you have. So examples are like being a single mother or being related to someone, like you can't be discriminated against because of who you're related to, who's in your family. That's what it means. Yeah.
That includes same-sex couples?
It would, although if the discrimination is happening because they're gay, then they would probably point to the sexual orientation ground and say they're being discriminated against on the basis of their sexual orientation. But it could be an example where both are relevant. Just depends on the situation. Yeah.
Can I just toss in another remark just on the legal side?
Sure.
There's been discussion, and I've heard a number of these discussions with the groups that I've been involved in about how legally to go about things. Human rights approaches are one way to go, but I believe, and I've commented to Elizabeth, that I believe that this society needs to have someone take a look at the legal approaches, to perhaps get a law foundation grant, to have the possible remedies looked at, whether it be judicial reviews against government or human rights complaints against government, but to look at it, what are the issues and what are the strategic litigation approaches, so that you can decide if there are some things that could be done on a cost-effective basis to bring the issues forward. So I've commented to a number of people, anyone who wants to get involved in writing a grant to the Law Foundation should be letting Elizabeth know that, so that someone can take a legal look at it. I'm a lawyer, I do public interest litigation. I'm also very sick, so I can't do it. But I'm telling you how to go about doing it.
Yeah, there's lots of options.
On our committee, right?
I would be on the committee, I wouldn't be litigating.
No. See, yet another important committee, the legal committee.
And I don't know if these are options that seem meaningful to folks, but of course there's also the colleges, the regulatory bodies for doctors. There's the Patient Care Quality Review Board. There are a variety of avenues that are not exactly litigation, but are places to name and identify and tell the story of what has happened to you, and places where accountability may be possible.
I would just add that I guess the process that I've been through has been very timely. So the current process is a human rights case, but the total process, I guess, like I was injured in 2006, and with the help of my practitioners, decided that I needed some services starting in 2009, and we're in 2018. So it's looked like a 9-year journey so far. So I just want to like acknowledge that people, you know, some people have been dealing with things for a long time. Some people have been 20 or 30 years. Yeah. And I forget what my point was because I have fibro-fog. It's thick enough to eat with a spoon right now. So I'm tired after how long we've been here. But yeah, I was just, we were talking about objectives, right? And different ways to get there. I'll remember what it was. I would say that I've tried a lot of avenues in that 9 years. So I've been really blessed to work with a lady named Amber Prince at a Tira Women's Resource Center. So if you don't have access to funding to hire a lawyer, or if you can't find a lawyer that will work on contingency, you could see what resources are available. They're in the same boat as class, right? Yeah. There's only so many resources available. I love the idea of finding someone that would be willing to champion the cause that will work for a small amount or a set fee or a donation. Or one thing I was thinking of is like a panel of lawyers where no one has to commit to the entire process, where they're working as a group to work on certain things, and they don't each have to put in 45 hours. They're each putting in an hour here and an hour there collaboratively. And also it creates more systemic change that way as well, because it's not just one person involved. It sort of trickles out outwards, like the raindrop in the puddle kind of thing. Yeah, and I would say that through this process, everything you push does create change. So for people that are out there and are thinking like, what should I do? Should I do it? Should I spend the energy? Do I have the energy? Like, I need the services that I've been requesting. I need them for my survival. I can't function without them. So I haven't had the choice. I haven't had the luxury of trying to decide whether or not to pursue. I'm lucky enough to live in Vancouver, so I have access to services here. A lot of people live more remotely and they have to travel to get somewhere. So there are individuals that are willing to work by phone, but again, that's limits your sources again, right? But like everything we've pushed in the processes along the way has caused change. Like there's been times when I wanted to give up, and one of the physiotherapists that was involved on the other side of things, because a lot of people dealing with systemic change have a foot in both camps. They're responsible for the patients. They understand what the patient's going for, but they also answer to their bosses, which is on the systemic side. So it's almost like a conflict of interest. So this one person said to me, like the most precious words ever. She said, like, do you have a pass key for Vancouver Coastal Health? Do you attend board meetings? Like, do you have a camera on our walls? Like, you have no idea what's going on. You don't know what you're causing. You don't know what you're stirring. Like, just keep pushing. Because when you're on the patient end, you're not party to whether or not you're creating change, because you're not necessarily going to see it. But like, if it's important to you and you need it, like, go for it. But you have to, like, that's the balance thing, how much you can put out, right? And I appreciate what you were saying of like, you know, I won't be the litigator, but maybe you could be on a committee, like doing what you can in like bite-sized portions.
I already am.
Yeah.
You should ask Lady Gaga.
Yeah, Lady Gaga's come up a lot in the community that I'm in as well too. Yeah, but even just like someone being willing to be a spokesperson. So anyways, I just wanted to say that like the PCQRB, I don't think it even existed in the beginning. I don't know when they were created, but like we've had situations where we've said like, what basis of discrimination are you using? What policy are you using? We'll get back to you. I'm getting back to us because they had to write a policy document. Okay, like a lot of ME stuff is new. Like there are policies to be created, right? So like when you push doors and push windows and ask for answers, I know litigation's expensive and I know it's not the only option, like awareness and advocacy is, but every single push is creating change. So yeah, there's been a number of things over 9 years where there's been evidence that it does make change. Yeah.
Well, if, do we have any more questions? Because we're,
Just one
wait,
very
yes.
last one. Just repeating, do you have any idea?
Do you have any idea roughly how many people have either one of these illnesses in the greater Vancouver area?
No. What we do, there's been no studies, there's no diagnostic code, no billing code, no nothing. So we base everything on the Canadian Community Health Survey. And if we extrapolate from that, which is kind of statistically dubious, but still justifiable, we're at, between the two illnesses, about 120,000 plus in British Columbia. Then you'd have to do the same kind of thing. You'd have to extrapolate what percentage of people live in the greater Vancouver area and figure that out. So it's a very rough estimate, but thousands, tens of thousands, possibly, depending on definitions, depending on all kinds of things, but these are the only numbers we have. They're large.
A lot of people are not diagnosed because ME is not well known. So
Yeah, and
whatever number we do have is not actually representative of how many people there are.
that's right. So if we don't have any other questions, I'd like to thank Laura so much. That was really, really interesting, and I think we're going to be having a lot more conversations. I know that your organisation doesn't want to take on a very large cause, but we might ask you anyway.
Our door is always open.
Thank you so much. It really was. I was a bit worried it was going to be a little tiny bit tedious because, you know, it's legal stuff, but it was actually very, very interesting because, you know, didn't you find like every second sentence was like, that's us, that's us, that's us. So, you know, it really resonated.
Good, I'm
So
glad.
clearly we have a human rights issue going on. There's no doubt about it. Thank you very much. Thank you so much.
You're welcome. Thank you.
And with that, I guess we're going to call this a wrap. Thank you very much for coming, for staying, for being our IT people, for sharing your stories, and for attending from home. And we look forward to reporting to you what comes up next. Don't forget, as you can tell, there's a lot to be done. Please let us know how you'd like to participate. Thank you. Bye.